Hi guys. How's everybody doing? It's Saturday, so this is a little bit different. Hope everybody is doing well. This week, and let's just switch over to the docket. Let's go back to the days. We had a pretty big update in the Courtney Clenny case. We've been hearing a lot of talk for about a year that the defense was going to be moving to disqualify the state attorney's office. This is the Miami-Dade County State Attorney's Office. In between, we had some activity where the defense moved to depose former, at that point in time, lead prosecutor Khalil Quinan on the grounds that he went through privileged communications that he shouldn't have been going through. He voluntarily stepped down. Shawn Abuhoff, who was the assistant DA, is now the lead prosecutor in this case. And there's still a whole bunch of stuff going on. But now this motion, I'm sure it's going to argue Khalil Quinan stepping down doesn't cure the problems. The behavior of the entire prosecutor's office is tainted because of the behavior of Quinan and maybe anyone else that was involved. So we're going to look at their arguments here. As far as updates, no, there is no trial date set. So everybody keeps asking that. Courtney Clenny has been in custody for what? Approaching, it's like 2 years and change now? It's been a long time, but the next dates with some action, there's a status hearing set for the 12th, and then there's a hearing set for the 22nd of May to hear arguments on this motion to disqualify. If there's a disqualification, I don't know if they'll move for another request for their defendant, for Clenny, to have release before trial, pretrial release. But it's going to take some time for a new prosecutor's office to learn the case and get a trial date set. So this might not look too different from the YNW Melly, except Clenny hasn't even had a trial one. But with that being said, hey, here to Sunflower Beth, good to see you. That guy Nick is in the building. Nicole's here too. Amanda, I have a Coke Zero in my fridge that says share a drink with Amanda. So that's you today. Hey, Tat Clouds, good to see you. And Miss Chris is here. Good morning. So let's make this big. Link is in the description if you want to look at the filing. You can see this was actually filed on the 30th. I didn't see it on the docket until yesterday. And very odd, but I didn't have to actually request this. They uploaded it to the docket. For everything else in the case, I have to request it. You can see this column's blank. But maybe they figured this was such a big deal. We're just going to upload the document here because people are going to flood our office with requests for it. So that was nice. That was nice. I do anticipate that on the 22nd, when they have the hearing for this, this is a bigger deal than some of the other hearings that have taken place where media has not been present. I do expect that if the local stations aren't in there, I feel like Court TV will go down to the courtroom again for this. So we'll probably do a stream on the 22nd to watch this hearing. But we've got the amended motion to disqualify the Miami-Dade County State Attorney's Office. This is amended because last year, in August, they initially filed a motion to disqualify the Miami-Dade County State Attorney's Office. And in the interim, they found out more information about Khalil Quinan and what he saw. They got 2 affidavits from people at the district attorney's office that were working as part of the filter team. It's a whole bunch of new information. We've got a beefed up motion to disqualify. So comes now the defendant Courtney Clenny by and through undersigned counsels and respectfully removes this honorable court for an order disqualifying the state attorney's office in and for Miami-Dade County from prosecuting the above referenced case against Courtney Clenny, and in support thereof states the following. So this is going to, if you haven't been following this or it's been a while, this is going to give you the top level summary of what's happened before this point. Courtney Clenny was charged by information with second-degree murder and was arrested on August 4th, 2022, in connection with the death of Christian Obumseli, which occurred on April 3rd, 2022. Attorney Frank Prieto was promptly retained by the Clenny family. Now, this is important already. Words are important. Attorney Frank Prieto was promptly retained by the Clenny family. This is an important theme throughout the parents' laptop case and the search warrant for the parents' iCloud accounts, because the issue of privilege stemming from the laptop charges was that the Clenny family, on one hand, communications between the law firm and the Clenny family were, as they argued, intended to be private communications in furtherance of the defense of Courtney Clenny, who's definitively their client, and also that there was also an attorney-client representation agreement between the Prieto law firm and the Clenny parents. And so that's two layers there that the state prosecution tried to get through and say, we didn't violate privilege by looking at communications between the parents and the attorneys. And Frank Prieto had to get on the stand. We've got a really crappy recording of that hearing. I think it's the only one on YouTube in the description. And the judge agreed with the defense that the state prosecutor violated privilege looking at these. So they're going to probably repeat this throughout, that the Clenny family, not just Courtney Clenny, but the whole family, the parents and Clenny, were, are, and have been, from nearly the beginning, I believe they argue September 2022, retained by these attorneys to represent Courtney Clenny as well as to protect the interests of Kim and Deborah Clenny. This oral agreement was later formalized in a written retainer agreement dated September 15th, 2022, covering attorneys Frank Prieto, Sabrina Puglisi, and Diane Karamis. The state of Florida is represented by Assistant State Attorneys Shawn Abuhoff and Kathleen Hogue, and previously included ASA Khalil Quinan. Oh yeah, it should have been, I was saying ADA earlier. My bad. On November 3rd, 2023, the City of Miami Police Department obtained and executed a warrant for the iCloud accounts of Courtney Clenny's parents, Kim and Deborah Clenny. The warrant was almost identical to one initially issued in March 2023, which had since gone stale. The warrant application, excessive in both scope and time, sought access to the entire iCloud accounts of parents from November 2020 to present, which at that time was through March 2023. Now I want to take a short pause here. So this stuff, they were still arguing to protect this information. It was never entered into discovery for the public to access. But around this time, I saw the discovery list for Courtney Clenny for her homicide case, her murder case. It was updated and included her iCloud account. And so I requested it, and it was a Celebrate extraction of her iPhone's Notes app. So you know that app where you can write little notes to yourself? It's like a journal, but on your phone. The whole extraction was there. The document's like 300 and something pages. And we looked through some of them. There's some videos and a playlist in the description. But they went back to like, I think like 2012 maybe? 2013? But like a decade. This extraction, the Celebrate extraction on Courtney Clenny's phone went back a decade. So, and to me, I get that she's on trial for a serious offense, but she only dated Christian Obumseli for like two years or so. So I was surprised to see that it just went all the way back to 2012, 2013. And I can only imagine, I accept this at face value that they went all the way back here with the iCloud accounts from the parents. According to the warrant application, law enforcement sought information from Kim and Deborah Clenny's accounts, quote, because of messages exchanged with Subject 1, known photographs taken of Subject 1 by Subject 3, and the commingling of financial accounts by Subject 2. See affidavit in support of warrant. Now, this is probably relating to Courtney Clenny. Despite the application's description of specific information sought with a limited time frame, law enforcement requested access to the entire iCloud accounts. This included data from 17 months prior to the April 3rd, 2022 incident, and data from 7 months after Courtney Clenny's incarceration, when she did not have access to a cellular phone to communicate with her parents. So, as a consequence of the information obtained from this overly broad warrant, law enforcement accessed attorney-client and work product privilege communications between attorneys Frank Prieto and Sabrina Puglisi and their client/parents, Kim and Deborah Clenny. That's confusing because that kind of makes it seem like Kim and Deborah are Frank and Sabrina's parents. But okay. Which occurred after Courtney Clenny's incarceration. The first privileged communication at issue took place in a group text titled Team Courtney, involving the attorneys, their paralegal, investigator, and Kim and Deborah Clenny. At no point, and let me hop over here. So Brooklyn says, wasn't this a self-defense case resolved 2 years ago? No, no. So last year, the laptop case was resolved. The prosecution voluntarily dropped those charges after Judge Laura Sharon Cruz, in relation to the laptop case, ruled that they had violated privilege by going through these communications. So at that point, they're like, all right, well, our hands are up now. We'll just drop these charges. So that case has been resolved, sort of, because there's still all these issues stemming from it spilling over into Courtney's murder case. So, yeah, Chelsea Lynn, yeah, were they trying to establish a pattern of behavior going back that far to 2012? I'm confused. That's 1,000,000% what they were doing. But is that acceptable to do? You know, there's all these rules where you're not supposed to use prior bad acts. You're not supposed to try to prove that somebody committed a crime on the date, the specific thing that you're charging them for, and claiming that they did on, let's say, January 1st of 2025. The state is not supposed to be able to prove their burden by just saying they did something bad a couple years ago. Like, that's not the way it's supposed to work. So, but prosecutors still always try to do this type of bad character, prior bad acts, all of that type of stuff just to get the jury on their side. I'm not a fan of that approach. And what's crazy here is I think the state has a lot. I don't think the state really needs to go that far to have a solid case against Courtney Clenny. But yet they're doing all these things that just make them look desperate. They don't need to be doing this. They have facts that look really bad for Courtney Clenny, and they should use the proper facts to prove their case. So, yeah, Chloe Alberts Revenge says YouTube is undertaking a terror operation against me. I wouldn't be surprised. I'll go to war. Big shout out to Tat Klaus for being a member for 5 months. Good to see you over here. I've seen you around in other chats. So nice that you guys are hanging out on a Saturday here. 5 months is cap. I love y'all. Yeah, I think, like, if you got a gifted membership and then sign up yourself, sometimes that breaks the length of time. But yeah, so thanks for being here either way. We can add like a 1 in front of it. FFS, good to see you. Says, Kat, welp, I'm here. I didn't get the notification that you're live right now. We're blocking each other again. No, okay, so I set this for 11 p.m. Eastern when I meant 11. So that's why no one probably saw this in advance. So my bad. My bad. Oh, Nem, you're right. Nem says, am I wrong? Didn't they use a big guy throwing knives at a pig? Was it another case? That's this case. But we were able to see that because they're trying to provide their expert witness list, get witnesses approved. So they had to provide like a CV and the demonstrative, what they plan to use, for that expert to be approved. So we've seen that because of the motions relating to getting that into discovery. But that hasn't actually taken place with trial. You might be thinking of the recent motion for release while Clenny awaits trial, because I believe they played it during that. And then, yeah, I'm always dropping the ball, Chloe. You know what it was? I think, like, I was gonna start it at noon, and then, I don't know. I moved it to 11 and then just did it the wrong way. Oh, goodness. Yes, Texas Cat. This is the OnlyFans girl that killed her boyfriend. Yes. And yes, so that guy, Nick, and I think one day we're gonna go and redo the Arthur hearing. It's a, basically a bond hearing when there's more serious charges in Florida. So it's like a mini trial. We could go back and watch that. I think it was like 8 hours total. But it really lays out like the facts that were available to detectives and then to the district attorney's office when they decided to place the charges against Courtney Clenny. But yeah, she, during her interrogation, she actually said she flung it like this from 10 feet away, about 10 feet away, while she was like leaving the kitchen area and he was still standing in the kitchen area. Just one time. She flings it, goes right into his like left subclavian artery. Medical examiner says that it was in like 3 inches or so deep, and he ends up dying of, you know, the blood pooling, insanguination. So yeah, so Turkeisha says, I'm not familiar with this case either. Yeah, we might do the Arthur hearing at some point. I keep waiting. I want to do it like when trial is scheduled, so it's like a warm-up to the trial. But there's no trial date being set. And hey to Dolly. See, all you gotta do is put Courtney Clenny on a stream, and Dolly will be here. Dolly is the most reliable person out here. One of my favorites. Make sure you guys go check out Dolly Talk, especially if you're looking for some reprieve from the Karen Reed case, because he's covering Judge Fleischer, everything going on in Judge Fleischer's courtroom, who I think everyone's a fan of. And good morning to Dustin TV. Speaking of the Karen Reed trial, Dustin TV has been my buddy in Millionaire Mel in her chat over on YouTube. Love it over there. So let's see. We've got, and this is the problem here. We're going to this point 9. At no point did anyone from the state attorney's office contact counsel to ascertain whether Kim or Deborah Clenny were represented by counsel, despite knowing that counsel represented their daughter. Nor did they reach out to Mr. and Mrs. Clenny, who were listed as state witnesses, to inquire about their representation in order to filter their names for any subsequent search. Now, this is the type of thing where when we watched this hearing back in May of last year, it was like May 12th last year, they were arguing that they didn't know, and the guy from the filter team and then Frank Prieto took the stand and testified at this hearing. And playing dumb isn't enough. We saw a similar issue in the YSL trial with Kenneth Copeland. Oh, we didn't know he had an attorney, and then we scheduled this ex parte hearing, this thing that we really needed. The state really needed to hold this ex parte meeting. We did it when we knew that his attorney was going to be traveling, and we threw a stand-in attorney in there who didn't know what was going on, and we just pulled a whole okey doke and then acted like it never happened. Except Brian Steele found out. So, like, it's one of those things that, unfortunately, we only find out about it when someone gets caught, and I wonder truly how often this happens. ASA Quinan conducted a search of the iCloud accounts and discovered the, quote, Team Courtney communications. The content of the Team Courtney chat, and there's a footnote, so let's see what that means. Okay, we'll read the whole sentence and then go down there. The content of the Team Courtney chat involved discussions regarding all matters related to Courtney Clenny's case, including communication regarding case investigation, witness testimony, defense witnesses, expert witnesses, financial obligations, defense theories, counsel's thoughts and impressions, and opinions on the case. Now, a lot of this stuff, all of this stuff gets into, you know, maybe this is stuff that on its face, the state also had equal access to already. However, if they were discussing strategy or the order of how they want to present things, this gets into an issue of the state being aware of the defense's strategy. That's very prejudicial to the defendant. When you get to something like a prosecutor viewing counsel's thoughts and impressions, what's the objective argument that, oh, that might not be prejudicial, that might not be getting into the defense's strategy or theory of the case or what they plan to do at trial? To me, there's no way to argue that if you're viewing counsel's thoughts and impressions, your filter team made a mistake at the very least. And again, same with opinions on the case. These were communications that the parties believed to be private and privileged, which is important. They had to have an expectation that this was a private communication in furtherance of Clenny's defense. Now, this footnote says that according to ASA Quinan, his search of the iCloud data did not reveal any associated name for the group chat. However, for ease of reference, all parties have agreed to refer to the subject messages as the Team Courtney chat. Okay. Oh, I wish... Oh. So they're citing the deposition of Khalil Quinan. Oh, I wonder I want a copy of that real bad. There's nothing I love more than depositions in criminal cases, because it's not that common. And when you do get a deposition in a criminal case, it's because something messy is happening, or someone's alleging the other side and engaging in something messy. The Y&W Melly trial, we recently had some depositions of detectives, and the one, I start reading the deposition, and her attorney, who's there through this deposition, they keep saying she doesn't know the answer to the questions because she's tired right now, because she's tired right now, because she's tired right now. What? So it's always messy reading depositions. I would love to get this. If it's either, I didn't see it attached as an exhibit here. I'm sure we'll hear more about it, or if I see it on something that I can request, we will definitely read that. We will definitely read that. Okay, so, wait, no, this wasn't where we were. I'm lost, chat. Okay, footnote. All right, we were here. During the unlawful review of privileged communications by ASA Quinan, and, you know, this might seem like a spicy declaration, but the judge has already found that Khalil Quinan looked at communications he wasn't supposed to look at in that laptop case, in the proceedings related to the laptop case. So this isn't just a spicy declaration. Her defense attorneys can factually say this because a judge who was the determiner of fact in that proceeding said, yes, that was an unlawful review. So they can wave this around as much as they want. During the unlawful review of privileged communications by ASA Quinan, he discovered discussions about a laptop in the possession of the Clenny family and the defense's investigation into its potential evidentiary value. According to Quinan, he denies reviewing any discussions in the Team Courtney chat beyond those pertaining to the laptop. He alleges that he limited his review to only a few messages immediately preceding and following the reference to a laptop. So again, this is coming from his deposition. In an unrelated written communication, Quinan asserts that upon review of the messages pertaining to the laptop, he immediately ceased review and went to obtain counsel from a supervisor, co-counsel, state attorney's office, appellate counsel, and defense attorneys. The exact number of defense attorneys and their identity is unknown to the defense. So wait, he just went and got counsel from like 4 different places? 1, 2, 3, 4. I mean, I'll never fault somebody for lawyering up, but sometimes it raises an eyebrow for me, you know. According to ASA Quinan, everyone he consulted with believed the communication was not privileged. So he's saying this now in this April 16th deposition. But yet, he can't name or identify the attorneys he's claiming in this April 16th deposition to have spoken to. And it's not, in a deposition, it would be tricky. You know, there's going to be an objection if Prieto, Sabrina, who was ever doing this deposition on Courtney's behalf, started asking him, what did you talk about with these people? But they're allowed to ask, you know, did you discuss anything related to this matter with somebody? Who was that person? Can you give us a name of one of the attorneys you met with? Disclosing the name of an attorney would not get into a privileged attorney-client privilege communication. But yet it seems like the way this is written, Quinan was like, I didn't think there was a problem because I consulted with so many attorneys and they told me I was good. Well, can you name one? No. So that seems like, that's why I want to read the deposition so badly. As a result, he continued his this makes it worse. Because, okay, if we stopped here, if we were just to be at the point where, like, Quinan, and again, I'm imagining, based on how this is written, I'm imagining the structure of this deposition. It seems like if this is where Quinan stopped, he could have just said, look, I talked to a bunch of people. I stopped after reading a few messages before and a few messages after wherever this word laptop was mentioned in these communications. That was the scope of what I looked at, and that's it. And I talked to attorneys and they said it was okay. And, look, I voluntarily stepped down. I'm really not trying to do anything wrong. If it stopped there, maybe I'd feel a little different right now. But then he answers in this deposition, well, after I spoke to them, I kept going. Like, what? So as a result, he continued his review of the iCloud and referred the matter to law enforcement. The state attorney's office, relying solely on the privileged communications and without any additional evidence, filed an information in, so this is the other warrant, the other case, the laptop case, Florida 24-2015, A, B, and C, charging Courtney, Kim, and Deborah Clenny with unauthorized access to the laptop. When drafting the arrest warrant for defendants Kim and Deborah Clenny, ASA Quinan approved the inclusion of attorneys Frank Prieto and Sabrina Puglisi as uncharged individuals who allegedly committed the crime alongside the charged individuals. Now, this was important because they were going to rely on a crime fraud exception. Attorney-client privilege is something that's held like you're not supposed to take attorney-client privilege lightly. There's an exception though, if you believe the parties, the attorneys and whoever they're representing together are committing some crime, some fraud in what they're doing together. So this was important for them to name it because it gives the hint, without the direct accusation, that the attorneys are up to some funny business. And lo and behold, at the proceedings that would come into play with this laptop case, Quinan, sure enough, did try to argue that it wasn't a violation of privilege because there was a crime fraud exception. Judge Laura Sharon Cruz was like, nope, not buying it. And she really pressed back on it. It was only later that the state attorney's office conceded that the undersigned counsels had not acted improperly. However, this concession came only after public accusations had already been made. Yep, and who here in the chat remembers the hearing where Sabrina Puglisi sounded panicked? And I was judging the defense attorneys for this. I already had some back and forth beef. And at this point, I'm a little more sympathetic to them because of all of this. They were right. I was wrong about it. I fell into the publicity about it. But Sabrina Puglisi was asking, she sounded really worried in court. Are there wiretaps on our phones, mine and Frank's phones? She wanted to get an answer out of the court and out of the state. And Quinan seemed like he didn't want to answer. And finally he's like, no, we're not seeking wiretap access to counsel's phones. And when that was happening, I was like, wow, she looks panicked. They must have done something. And it wasn't that way at all. So Dolly says public pressure mass campaign sponsored by Dolly, the Free Courtney campaign. Oh my goodness. Hey to Idiot Wind, good to see you. And then Nem says very shady. Yeah, and that's the thing, like, I do not think Courtney Clenny has much of a chance at all of being found not guilty, of a jury believing that she was justified in use of force against Christian Mobenselli. I think I don't know. There could be facts I don't know, and I reserve the right to change my mind, but I really just don't see it. I just don't see it. And I just don't get why the prosecution had to do any of this. Like, they could have had the trial already, and in my opinion, they were very likely to get a win, and they just went down this rabbit hole. So, and holy moly, Idiot Wind! Guys! Holy moly. Thank you, Idiot Wind. This is incredible. Oh my gosh. Idiot Wind just gifted 50 memberships. Like, the whole chat should be green. So if your name is green, guys, make sure you come thank Idiot Wind. This is super, super, super generous. Holy moly. So, and you guys get to yell idiot in the chat. So this is super generous. Thanks so much. I'm so excited that you're here, and then thank you for bringing 50 gifts. Yeah, for always, forever, for life says, oh my God, I've been waiting for Courtney Shaney, Courtney Clenny girl. But yeah, I mean, this case is just slow moving. It just, Dolly says in all seriousness, she's guilty as hell. It boggles my mind that the state has to play these games. Like, what? Why? So, just like, and I hate it. It like drives me nuts because, the Daily Mail UK, and you know, Daily Mail is so messy because they're a UK publication and they're the ones that broke some story like 2 or 3 weeks ago that Courtney Clenny put her house on the market. She's selling the house that she bought. And cool, on one hand, I want to roll my eyes and say, well, you probably bought your house to put your money in there when all this was going on. So, you know, maybe a little bit of karma there. But I don't even want to say that about somebody because just because she happened to have the funds and I happen to think she's guilty, if Courtney Clenny, who had millions from OnlyFans, and she also was making a lot of money doing brand deals and whatever on Instagram, like she had stuff going for her. If she needs to put her house up for sale to continue fighting for her defense, who has a chance in hell if they don't have millions behind them? So I had to check myself when I reacted to that because it's like, I can't look at her putting her house up for sale and be like, haha, and then not see the bigger picture on why that's a problem. I mean, we're 2 years into this, no trial date, largely in part because the state attorney's office was screwing around. So, like, and right as we're talking about prosecutors behaving badly, Peter Ortiz is in here saying, hello, fellow slime. Good to see you. Speaking of Peter Ortiz, birthday on Monday, right? Cinco de Mayo's coming up. That's Monday. 2 days. So we're going to do a stream. I don't know how long it can be because I do have to work. But we're going to get together. We're going to do a stream. And it'll kind of be anything goes. Any case you guys want to talk about. Anything that won't get me banned. We'll do a Cinco de Mayo party. I think it'll be a good time. It'll be a good time. So hope everyone comes to hang out, bring some tacos. Emery Dawn just says, yay. So that's how I feel too. Dina L, heck yeah, can't wait for this trial. I will drop my workload when this finally has a trial. I will be streaming this trial. I will not miss this trial, you guys. And let's see. Yeah, Idiot Win says prosecutors do this because they're not used to getting consequences. Yep, and think about the fight to keep things under seal and keep cameras out of courtrooms that, you know, typically there isn't an issue with cameras being in there. But not wanting to have the spotlight in the few courtrooms around the country where cameras typically aren't a problem. The attorney's office are like, please don't put sunlight on us. Please don't do it. So, you know, the world is changing. More eyes are paying attention to different things. The public's getting pissed off. And even if your local constituents aren't really noticing local news about what's going on, they could open Twitter and they could open YouTube and see somebody saying, like, the taxpayer dollars that they're putting into the pool are getting paid out to somebody who was wrongfully convicted. What are the prosecutors doing? Let's look at them. Like, they don't want the spotlight on them. Like, it's crazy. So we were, let's see. They included the attorneys, conceded that they hadn't actually acted improperly after accusing. And then we're here. So after the arrest of Ms. Clenny's parents, it became clear to the defense that the state of Florida had viewed attorney-client and attorney-work product communications. Once the extent of this breach into the defense camp was learned, counsel sent correspondence to the state demanding the immediate return of privileged materials. So there's a letter dated February 15th, 2023, attached here too as Exhibit A. So we're going to go and look at this. There's 3 of them. And It's going to feel familiar. Again, we're in Miami-Dade, but it's going to remind you a little bit of Fulton County. Let's see, Exhibit A. All right, so we've got this again, this is 2023. This isn't 2024. This is 2023. Sending over to Chief Assistant Kathleen Hogue, Shawn Abuhoff, Khalil Quinan. The state of Florida's review and possession of attorney-client and attorney-work product communications. Dear Chief Assistant Hogue, please be advised that undersigned counsels demand that the state of Florida, their investigators, and their law enforcement partners that were complicit in obtaining attorney-client and attorney-work product communication return any and all materials immediately. All communications between Ms. Courtney Clenny, her attorneys Frank Prieto and Sabrina Puglisi, their staff, and their investigators are privileged. Further, any and all communications between Kim Clenny, Deborah Clenny, and their attorneys Frank Prieto, Sabrina Puglisi, and their staff and investigators are privileged. Demand is made for the state to return all the materials to undersigned counsel immediately. Through improperly obtained iCloud warrants, investigators that were assisted by the state obtained extensive communications between all parties referenced above. All the above parties have been represented by this firm since 2022 in connection with providing legal advice, legal services, etc. So they're laying it all out. Like, they're spelling it out in this 2023 letter that no matter which angle you want to take it, whether something's work product or a communication between a retained client, it's privileged either way. Communications were made with the expectation of the privacy and privilege between the clients, attorneys, the attorney staff, their investigators, and or third parties that were necessary in furtherance of the rendition of legal services. The state and their investigators did not use a quote taint team and or a filter team after serving the overbroad and not properly limited in scope and time iCloud warrants. It is clear that the state and their investigators reviewed privileged communications as they have released portions to the media and used these protected communications in subsequent warrants. These communications are protected by the attorney-client and attorney-work product privilege. The state clearly had knowledge that they were reviewing protected material. And a quick pause here, because if you haven't been following along, there was a point in time where the state was requesting a gag order against Frank Prieto specifically, but Courtney Clenny's defense team in general, for making statements out of court that they said weren't true and were completely unfounded. And again, this is another moment in time where I was like, I felt like the defense attorneys were playing dirty, because at first I believed it's a big deal for a prosecutor to ask for a gag order. I think Adrienne Love was pretty bold in her request, but I thought she was a bit exceptional rather than that being the norm. So here I was like, all right, they're saying that Frank Prieto specifically went on court TV and mentioned that Christian Obumseli, that there was information pointing to Christian Obumseli having a bad relationship involving some type of sexual abuse with his father. That's what the state was saying, among other things. They when the judge pressed them, the state shrunk their scope to just being that thing, even though they wanted a much broader, like, don't speak to court TV at all. But even when they were narrowing it, I was like, wow, that seems reasonable. They're making stuff up about the victim and the father. Well, lo and behold, when I get this Celebrite extraction from Courtney Clenny's phone, that's where that detail comes from. So this detail that attorneys, the state prosecutor's office, they didn't want the defense attorneys to go on court TV and talk about, that they're saying was made up by the defense team, actually came from their overbroad extraction of Courtney Clenny's phone. So lo and behold, they put their hands down, and there's a very limited gag order that neither side should be saying things that are untrue to the media. But I looked at that and it's just like, in retrospect, once I learned more about what was going on, the audacity of the state to ask for a gag order because they're pissed off that the defense attorney mentioned something that only came out because they went and grabbed this whole extraction from Courtney Clenny's phone. How do you reconcile that? Brooklyn says not Celebrate again. You know. Yeah, Peter says, since when did Atlanta move to Florida? Look, we're not that far away. We're not that far away. It's like a 7-hour drive with no traffic from where I am. Should the state not provide all these materials / communications and any and all copies that may exist to counsel, demand is hereby made that all materials be sealed and provided to the court until such time that evidentiary hearings are held on the violations of these privileges. So again, this is February 2023. This is before we saw all those hearings and proceedings play out. The state should cease and desist its review of all communications between the above clients and their attorneys, the attorney's staff, and their investigators. Finally, undersigned counsels demand that the Office of the State Attorney, 11th Judicial Circuit, recuse itself in this matter. So this is where we first started hearing that the defense is moving to disqualify the state attorney's office. And you've probably heard me say it like, what are they doing with that? What's happening with that? And it's taking up 2 years of the court's time while the defendant is in custody awaiting trial. And it's all coming down to the state's behavior. One prosecutor or the state, whatever. It's one and the same to me. So that was Exhibit A. That was their first letter, really putting them on notice in addition to making their request to turn over the materials. Okay. I think we're on this one. I think this is where we were. So adding to the state's misconduct, they failed to respond to this request, and there is no evidence that they deleted the information. So Florida Bar Rules is the footnote of professionalism, Rule 444B. 444. A lawyer who receives a document or electronically stored information relating to the representation of the lawyer's client and knows or reasonably should know that the document or electronically stored information was inadvertently sent must promptly notify the sender. So, yeah, so this is in relation to not just them responding to the request. This is about them potentially still holding on to the information. I feel like this is going to come into play because it's going to become clear at some point, I'm sure, and we're going to see an argument later in this motion that they still had the material, I'm sure. Further, after no response was received, counsel for Ms. Clenny sent a second letter on February 28th, 2023 that also garnered no response from the state. So they attached that as Exhibit B. We're not going to reread it again, but is it about the same length? That's the first one. Yeah, it looks about the same. So just to double check on that. There was only that one underlined thing. If there was more bolding and underlining, we would have read it. Okay. Further, after no response was received, they sent that second on February 28th that also garnered no response. On June 26, 2024, so we're zooming ahead quite a bit here, right? We're going from February 28th, 2023 to June 26, 2024. This was a big day. This was big news. On June 26, 2024, the court entered an order granting a motion to exclude and or suppress filed in case numbers. This was the laptop case. The order found that the communications reviewed by the ASAs and law enforcement were privileged as attorney-client and or work product communications. So again, this was the judge not buying the crime fraud exception that the state tried to argue. On August 20th, 2024, okay, and since we're jumping to August, because Judge Laura Sheeran Cruz said we're suppressing this information, and because it was the only information, the only evidence on which the state had to file the arrest warrants for Kim, Deborah, and Courtney in relation to the unauthorized access of a, electronic device, because the judge had just taken away their only evidence. They're not stating it here, but like right away, like the next day, the prosecutors dropped those charges. On August 20th, 2024, the defense filed a motion to disqualify the state attorney's office based upon the review of the Team Courtney chat. Subsequent to the filing of the motion, the defense was made aware of an additional and even more egregious breach of privilege by Assistant State Attorney Khalil Quinan. After a public records request made by a third-party defense attorney, I wonder if this was Jude Facadomo. I wonder if this was Jude Facadomo. After a public records request made by a third-party defense attorney, it was revealed that ASA Quinan had also accessed another privileged communication sent from attorney Puglisi to Courtney Clenny's parents. The communication included an attachment titled Courtney Clenny Checklist of Things to Do. Privileged. And again, the state attorney's office tried to argue that just because something's titled as privileged doesn't mean that it's privileged. Fair enough. But when it's a checklist of things to do for a defendant, seems like a strategy, potential order of the case. Yeah, seems a bit like work product. Upon opening the communication, the first page of the document clearly displayed the fields from, sent, to, subject, and attachments, with the from being the attorney for Courtney Clenny, and the attachment specifically named as Courtney Clenny of Things to Do, privileged document. Despite these obvious indications that the communication was privileged, ASA Quinan forwarded the email, along with the privileged attachment, to law enforcement on December 29, 2023 at 6:01 p.m. ASA Quinan saved the email and attachment under the title Haas email. The second page, I can't say Haas without thinking of Jen McCabe. It's not even spelled the same way. It's Hass. The Haas long email. The second page of the attachment contained detailed bullet points outlining the defense's trial strategy. The procedure in the state attorney's office when a Chapter 119 public records request is made is to provide a copy of the requested information to the assigned assistant state attorneys. In this case, ASA Quinan volunteered the privileged document only after he was made aware that the document was provided in a Chapter 119 return. ASA Quinan alleges that he did not even remember seeing the email with attachment because it was so inconsequential, while ASA Quinan attempted to excuse his conduct by citing personal stressors, including late night work, the end of the year, his wife's pregnancy, and construction. Deposition of Khalil Quinan. So the deposition's up to 61 pages so far. None of these circumstances justify the review and dissemination of a clearly privileged communication, particularly one so plainly marked as such. I'm not trying to not sympathize with people having things going on in their life. But this is spanning from just before February 2023. And at this point, whenever this specific activity, did they give us a date for the public records request? It just says after. So, sometime, let's say like August 2024, around that time. Are you that busy for that long? Because maybe you should consider saying, like, you know what, DA's office, I don't want to be the ASA anymore. But yeah. Idiot Win suggests for a Monday case. Oh gosh, I gotta learn how to say it. Is it just John Juka? Or is it like Giuka? I'm gonna practice on Sunday night. I'm gonna practice how to pronounce this name for Monday. Oh my goodness. Yeah, Peter Ortiz's DAs aren't practicing law anymore. They're pushing agendas. And that's what's interesting. I feel like this is, at least when it happened, I feel like it's gone a bit under the radar because it's taking so long. But I do feel like when this case, they didn't want to arrest Courtney Clenny at first. They had her speaking with police for hours and she wasn't arrested for like several months, really at the response of public pressure and the family. When they finally arrest her, they make a big press conference about it. And now it's suddenly like their baby case, right? You don't want to prosecute, but now you do. And now you're acting like this is like your shiny object case. And then you do all this with it. But typically with a high profile case, that's a lot of stardom for the district attorney's office. And I feel like two years ago, that's what this could have been for these DAs. So, okay, Juka. On Monday, I feel like I'm going to be like, we're going to talk about John Giuka. Oh my goodness. Yep, mermaid in a wine glass. Love that. Says, this is what happens when you think you are above the law. Yep. And it's kind of like you see him saying, I'm busy in my personal life. We know he stepped down voluntarily. It's almost like his decision to get out of the way is only happening because, like, the laser of the law is finally, like, coming at him. And he's like, oh, I'll just move myself out of the way now before I get some type of consequence. I'm only going to step aside so I can avoid a consequence for myself. And not because maybe it was the right thing to do earlier on. While ASA Quinan attempted to excuse his conduct by citing his personal stressors, including all those things, none of these justify the review and dissemination of a clearly privileged communication, particularly one so plainly marked as such. After learning of ASA Quinan's undisclosed further review of privileged email communications, the defense sent a third letter demanding the return of attorney-client and attorney-work product communications. And now let's see if this one's different. Let me see. We're on page 6, so I remember where to come back to. We'll go down to this third one. So the beginning's the same, and this looks a little different. Yep, so we have some difference here after the beginning. So please be advised that once again, we're demanding, all of these materials. All communications between Miss Courtney Clenny, her attorneys, everything that's privileged. Let's see. And this is new. Okay, so this is where we get new stuff. Demand is made for the state to return all privileged materials to undersigned counsel immediately with a letter certifying compliance with the defendant's request. So put it on paper. As the court has already found, all the above parties have been represented by this firm since 2022 in connection with providing legal advice, legal services, etc. So this is new because now the 2 letters that were sent in February of 2023, they didn't have Judge Laura Sharon Cruz's order yet. Now they have that as ammunition. So communications were made with the expectation of the privacy and privilege between the client's attorneys, the attorney staff, their investigators, and or third parties that were necessary in furtherance of the rendition of legal services. The court has further found that the state and their investigators reviewed privileged communications. The court, in her written order on June 26, 2024, and in her oral pronouncement on January 24, 2025, determined that the state improperly reviewed protected attorney-client and work product privilege communications. This is the third request for privileged materials made. Recent court hearings indicate that the state of Florida may have maintained privileged materials. Oops! Oops! Therefore, any communications that remain on the server at the state attorney's office in possession of the above-mentioned assistant state attorneys, other attorneys / interns / civilians / paralegals / investigators working on these cases, or who had access through Chapter 119 requests, law enforcement, etc., must immediately turn over all privileged communication. Should the state not provide all these materials / communications, including any and all copies that may exist, to counsel, demand is hereby made that all materials be sealed and provided to the court. Finally, undersigned counsel's demand once again that the Office of the State Attorney, 11th Judicial Circuit, recuse itself in this matter. Oh, look at this sign-off. Guys, let me zoom in. Chat, read the sign-off here. They said, please govern yourselves accordingly. Oh my gosh. Crazy. I love that. Did they use that in the other ones? And I just didn't look? Okay, so they did use it in the second one. Oh, they've used it for all 3. Oh, I like that. I like that. That is great. All right, so we'll go back up to page 6 here. Please govern yourselves accordingly. Oh my gosh. Chad, if you ever send something to like a district attorney's office, please sign off. Please govern yourselves accordingly. Let's see. All correspondence requesting the return of what the court deemed to be clearly privileged material sent to all state counsels, ASA Quinan, ASA Kathleen Hogue, I think they spelled her name wrong here, and ASA Shawn Abuhoff, was met with silence from the state of Florida. You know who could have sorted this out? A glorious man by the name of Stephen Gosney, who was hired to bring ethics to this district attorney's office, and someone got their panties in a bunch and got upset because he has a bunch of books, and one of them was called Death Penalty Desires, and the author didn't understand the purpose of the book and thought it was just some weird thing. So there's a whole big PR thing about it, and I think Stephen Gosney may have left on terms that were beneficial to him, although he didn't want to give up the position. He would have been in there and been like, you know what you should do in response to requests like this? You should respond to the request. Maybe you should do that. Maybe you should do that. So they get a good egg in the Miami-Dade State Attorney's office, and they get him out. They kick him out as soon as he gets in there. Just crazy. Just crazy. In prior pleadings and during court hearings, ASA Khalil Quinan repeatedly represented to the court and to defense counsel that he ceased all review of the Team Courtney chat immediately after discovering the text communication referencing the laptop. I knew this was going to come back, you guys. His statements conveyed that he did not review any further materials after encountering the laptop reference. However, after the defense independently uncovered, through a third-party public records request, that ASA Quinan had in fact reviewed and disseminated an additional privileged document, the Courtney Clenny, the Courtney checklist of things to do, privileged. It became clear that his prior representations were misleading. Oops! Oops! What a hot mess. At his deposition, ASA Quinan attempted to reframe his prior statements, asserting his claim that his, quote, review immediately ceased, quote, end quote, should be understood, quote, in a vacuum. What if you confronted somebody like, were you talking about me with this other person? And they're like, well, you know, they mentioned this one thing that you did and I shared one thought on it, but then that was it. Never again. I never talked to them again. And then you find out that they had a conversation again with that same person months later about a totally different scenario. And then they said, well, I didn't think to tell you that because you should look at it in a vacuum. What? This just seems like you messed up and then misrepresented it. So Frank and Sabrina go on here to say that meaning solely limited to his review of the Team Courtney chat and not to his broader review of other iCloud materials after discussion with other members of his team and counsel at the state attorney's office. All right, so this is in the deposition again. Despite becoming aware of the fact that he had continued reviewing privileged materials beyond the Team Courtney chat, ASA Quinan failed to proactively inform the court or defense counsel to correct the record. Had the defense not independently discovered the additional review through public records, ASA Quinan's violation would have remained concealed. It is only after the defense uncovered this misconduct that ASA Quinan sought to provide an after-the-fact explanation for his actions. Oh my goodness. And I'm pretty sure that Quinan made representations as such to the court about this. The defense filed a motion to determine the confidentiality of records, arguing that the attachment detailing the trial strategy was privileged opinion work product. In an oral pronouncement, the court agreed. I think this was back in January. Additionally, despite the apparent privileged nature of the communication and the later confirmation by this court that the document constituted quintessential opinion work product, in her order granting, in part, defendant's motion to compel the deposition of Assistant State Attorney, Quinan continued to maintain that the materials he reviewed were not privileged. Now that's interesting, because if you're arguing that something wasn't privileged, why would you need to argue that if you didn't look through it? It doesn't matter. There isn't even a privilege argument because nothing was viewed. So why are you still, what was he just like, I mean, even if I did, no, it's not privileged. Like, what? What? Oh my goodness. Following the defense's discovery of this breach, oh wait, hold on, wait. Did I skip something? Okay, yeah, right here. So he continued to maintain that the materials he reviewed were not privileged. He testified that he did not seek guidance as to whether this email was privileged from his supervisor, co-counsel, or any other attorney at his office. Okay, so this he swears was fine to do. So the document that had privilege in the name that he missed, he didn't go and seek any advice or guidance on whether this was privileged. He just decided on his own. Following the defense's discovery of this breach, ASA Quinan did not immediately withdraw from the case. Instead, he engaged in extended litigation, arguing that the communications were not privileged. Only after significant motion practice and this court's rulings did ASA Quinan finally withdraw. And this was really, like, a lot of this was not, this wasn't in streamed hearings. The most recent streamed hearing I can think of is the motion to compel the testimony. There was a confidentiality issue, and I think it's NBC6. It's a local Florida station in Miami. They got wind that something was involving the prosecutor, and they were arguing, the public has the right to see this. So the hearing was really more about the confidentiality issue. Does the press have the right to access this? Should it be suppressed? I would have loved to see more on this extended litigation where Quinan is trying to go down with the sinking ship, continuing to argue that the communications were not privileged until he finally just withdrew. Additionally, throughout the litigation, each motion was signed or adopted by ASA Abuhoff and Hogue, showing their joint participation in the state's position. So this is probably why we're going to start, we're arguing so far that Quinan, but the other prosecutors who are now continuing to prosecute this case against our client, they're complicit, at least in their continued participation to support Quinan's arguments here. Compounding this prejudice, the defense later learned that approximately 60 individuals with the state attorney's office accessed Courtney Clenny's V-case file. See list of individuals attached as Exhibit D. That's probably just a long list of names, you guys. Although ASA Quinan testified that the privileged communications he reviewed were maintained on external drives and were not uploaded to the V-case system. Oh! He said this very early in his deposition. He said it on page 15. Without a full investigation into everyone who accessed the case file, it's impossible to determine the full extent of privileged information exposure. Despite the number of people with access, no disclosure logs or filters were produced to confirm the scope of access. And this is kind of an interesting argument, just for the sake of, if a court found it necessary, if the court doesn't believe that a disclosure of the log would be enough, if an argument is raised that, a disclosure log, we still wouldn't know because there's external devices. If it gets to a point where the remedy would be for the defense to be able to sit through and interview more than a dozen of these 60 individuals, now it becomes an issue of time, right? Where it just seems more reasonable to disqualify the state attorney's office and let it go to another area. Investigation into these individuals would require extensive delays, further prejudicing Ms. Clenny's desire to proceed to trial. On April 30th, 2025, while in open court and under oath, Assistant State Attorney Shawn Abuhoff and Kathleen Hogue each affirmatively stated that they did not personally review any of the privileged communications at issue. At no time during the review of the iCloud material did law enforcement or the state attorney's office establish a filter to prevent the review of attorney-client or work product privileged communications with respect to the iClouds of Kim and Deborah Clenny. Consequently, privileged communications were reviewed by both law enforcement and the state attorney's office. And this sounds crazy, and this isn't just the defense arguing that we haven't seen evidence of a filter. I mean, that's part of it, right? We haven't seen evidence of it. But during that May 12th hearing last year, I guess I said earlier at the beginning of this video, I thought it was someone from the taint team, but there was no taint team. It was just a staff member, a rookie staff member that took the stand at this hearing. And he was asked, did Quinnen tell you to filter anything? He's like, no. And I'm pretty sure they got into a line of questioning that was like, the staff member raised concerns about it and asked, like, should I be filtering anything? And Quinnen was like, don't worry about it. Something to that effect. So it's not just that the defense attorneys are saying they can't show us a taint team. They can't show us that the work was done to filter stuff. They have no record of that. They also have testimony from someone who was given the okay to just, yeah, go ahead. Look at it all in one giant vacuum. The improper and unethical actions of the prosecutors assigned and the state attorney's office have led to a 1-year delay in Ms. Clenny's case. This delay has significantly prejudiced Ms. Clenny's right to a speedy trial and to prepare her defense uninhibited by government intrusion into confidential strategy. And at the end of the day, whatever I feel about Clenny's factual guilt or innocence, these are two things I care about. Right to a speedy trial and right to prepare your defense uninhibited by government intrusion into confidential strategy or anything else that should be protected by attorney-client privilege. So, we're going to get into legal argument, but not before. Holy moly, big thank you to Full Drinking and Half Thinking. Says, wink love, hope all is well. Keep the press, you do amazing work. I'm glad you're here. Please do some Courtney Clenny breakdown content when they get a trial date. I know it's like, it's so spaced out right now, but there's so much available for discourse relating to this case. The legal stuff aside, the public commentary and discourse reacting to, when the news first broke. You had some people saying, well, what did he do to her? And as a social commentator, it's important to think, what is it that makes people see somebody did something and just assume the other person must be guilty? And then the reverse, there's a whole area where people are saying, we don't like the victim in this case. There's a subset of discourse. We don't think the victim was a good person, so we don't really care if the government is playing dirty. Right? And there's just so many layers of commentary, so many avenues of discourse that could come out of this that I think you would be really great at handling, Full Drinking and Half Thinking. So it's huge thank you for your support. You guys make sure you go check out Full Drinking and Half Thinking. And it's Saturday. Are you live tonight? I think Saturday is your night, usually like 8:30. You could do a Cinco de Mayo pregame. Okay, I see scheduled for 5:03. Is that right now? Okay, hold on. Oh my gosh, guys. Full Drinking Half Thinking is going to be talking about, I think at least, because it says Harambe Heaven, the whole discourse about can 100 men, like humans, take on one gorilla. So we will be doing that after this. And speaking of gorillas, shout out to the Diane Fossey Gorilla Foundation. That's who's always on my hat. They took advantage of the social media coverage and talking about, what is it like when humans go up against a gorilla? So they took the opportunity to talk about, gorillas, good relations with their reserves, the humans that are working on their reserves, the relations they have with the gorillas that live there, the conservation efforts. They went all in to show gorillas some love this week. And that, if you treat them right for the most part, they're not going to try to fight you. But I loved that. So I can't wait for this Full Drinking Half Thinking. I saw the internet going into these rabbit holes of like, okay, what about a polar bear instead of a gorilla? Like, people have been talking about this nonstop. Okay, FFS says every time I go to Full Drinking and Half Thinking, I end up full drunk. That's why they do it typically at 8:30. Peter Ortiz says, to some, the victim is to blame. And I actually I have an interest in cases where it looks like things are one way and then it turns out it's not, right? Because it's not always, and again, it comes down to the state getting it wrong, prosecutorial discretion with who they want to choose when it looks like it could go either way. But a lot of people, once a prosecution team has decided we're going to charge one person versus another, the public, for the most part, just runs with that being the person who was actually guilty just because they were charged. And sometimes that is the correct way for things to play out. And then other times there's like some type of like, oops moment. Something comes out, some piece of evidence, and it's like, oh wow, it's the other way around. It is the other way around. Yeah, Texas Cat, my fellow cat, is going to come hang out here with FDHT. And yeah, we got to do the acronyms. It's a bit easier that way. Big thank you again to Full Drinking and Half Thinking. Again, Idiot Wind earlier with the 50 gifted subs. FFS out here with the all caps. And Tat Clouds for hanging out. We are going to get into the legal arguments. And kind of at this point, you know, we're not looking at the Florida case law, but attorney-client privilege isn't something that's just a Florida thing. It is a fundamental concept of constitutional jurisprudence that a criminal defendant is entitled to a fair and impartial trial, irrespective of the crimes charged. So they're going to cite State v. Fitzpatrick here, a Florida case. A fair trial cannot exist in the absence of fair and ethical prosecutors, those charged with the unique power and extraordinary responsibility to assure that justice is served. And then they cite here, let's see, Berger v. United States, going all the way back to 1935, so well established, noting that a prosecutor's interest in a criminal prosecution is not that it shall win a case, but that justice shall be done. It is as much his duty to refrain from improper methods calculated to produce a wrongful conviction, as it is to use every legitimate means to bring about a just one. As so poignantly explained by the Florida Supreme Court, a prosecutor has a duty not only to fairly present the evidence and permit the jury to come to a fair and impartial verdict, but also properly functions in a quasi-judicial capacity with reference to the accused, to see that the accused is accorded a fair and impartial trial. By the nature of their position, prosecutors direct the power of the government against an accused person. They say, see Ruiz v. State, Florida case from 1999, reversing conviction and vacating death sentence in part due to prosecutors' attempt to tilt the playing field by invoking the immense power, prestige, and resources of the state. Therefore, prosecutors must be ever mindful of their awesome power and concomitant responsibility to reflect a scrupulous adherence to the highest standards of professional conduct. So we've got Martin v. State, DeFreitas v. State. Prosecutor must seek justice with the circumspection and dignity the occasion calls for. A criminal prosecution is not a game where the prosecution can declare, "It's for me to know and for you to find out." We hear that one so much. Maybe not in those specific words. But boy, it's like every case I've been following for the last few years, there always seems to be at least one instance where the state is playing that, you can find that out on your own, even though we have the duty to disclose. So, and a prosecutor is duty bound to remember that obtaining a conviction at the expense of a fair trial is not justice. Shout out to that. I agree. And they've got a cite here, a footnote. Aside from constitutional expectancies, the ethical obligation of a prosecutor is specifically laid out by the rules regarding the Florida bar. A prosecutor's heightened duties are likewise reflected in the rules regulating the Florida bar. Rule 4.3.8 is entitled Special Responsibilities of a Prosecutor. The commentary to the rule provides that a prosecutor has the responsibility of a minister of justice and not simply that of an advocate. So there we go. You have extraordinary capacity here. You're not just an advocate for the people nor the victim. You're not just an advocate. So here, The Office of the State Attorney for the 11th Judicial Circuit in and for Miami-Dade County violated their fundamental duties by reviewing attorney-client and work product privilege communications. These communications gave them access to the defense trial strategy. In the face of such violations, the confidence and trust that Courtney Clenny will be prosecuted fairly by the state attorney's office is significantly undermined, if not extinguished. So here we go. We're going to go, and we're going to get your favorite word, some of you in the chat. So I get to say a word very often. Please enjoy it. FFS says, I remember 1935 like it was yesterday. I have to come to terms with it being May 2025. Substantial misconduct and irreparable taint. Substantial misconduct has been conclusively established. Prosecutors access defense attorney, client, and work product privilege communications, including a document later ruled to be quintessential opinion work product by this court. The iCloud warrant obtained by law enforcement, with the knowledge and approval of the state attorney's office, sought information far beyond permissible bounds. Communications between Courtney Clenny's parents and her defense team, occurring after her incarceration, were improperly accessed. As this court correctly observed, the prosecutors should have understood the communications to be work product as soon as they saw the communication was from Courtney Clenny's attorneys and was related to her murder case. But remember, what did they do? They knew that they had to act like the defense attorneys were up to something shady. They had to name them as individuals of interest in the affidavits for the arrest. They had to act like the attorneys were up to something no good. Which to me suggests they knew they would need an excuse in the future. The misconduct was compounded by the later discovery that ASA Khalil Quinan had continued to review the iCloud materials and discovered a privileged document titled Courtney Checklist of Things to Do - Privileged DocX. Despite the document's clear labeling and contents, ASA Quinan did not inform his supervisors, nor did he seek clarification about privilege. Instead, he forwarded the document to law enforcement, made excuses as to understanding its true nature, and continued to maintain that it was not privileged, even after this court's ruling. ASA Abuhoff and ASA Hogue later adopted and ratified this conduct through signed motions and court arguments. ASA Hogue, as Quinan's supervisor, bears responsibility for this failure to supervise and ratification of misconduct. Florida Bar Rules of Professional Conduct, Rule 4-51C. Moreover, the defense later learned that nearly 60 individuals within the state attorney's office accessed Courtney Clenny's file in the VK system. Okay, so they actually know that it was accessed and not just had the opportunity to access and couldn't tell whether they had or not. Maybe I misread that earlier, but I thought earlier it was only arguing the possibility. But here it says accessed the VCase file. Why so many individuals accessed, again, the case is unknown, as only 3 prosecutors have ever been assigned and appeared in court on the matter. That's interesting. I don't know, maybe it's just something that it shows that it was accessed. But to me, I'd want to be able to look into that, or I'd want something certified that the office looked into it and found an explanation for it. Although ASA Quinan testified that the privilege materials were not in VCase, without investigating all 60 individuals, the defense cannot determine whether additional privilege information was viewed. Here we go. This is a huge argument, I think. Requiring such an investigation would cause unreasonable delay that has already occurred solely due to the state's own misconduct. How are 60 people accessing this thing, though? like this could just be a technical error, right? But at the same time, like, how do you even trust this office to go and look at themselves at this point? And I'll say this, I think Clenny might have a better chance just being able to go through this trial and call out this misconduct. So you know, I'm sure they'll be able to ask certain questions that get these issues in front of this jury, where if they move it to another jurisdiction, maybe they wouldn't get to ask this fair play type of question and get this idea out in front of the jury. And, you know, that's kind of a jury nullification approach, maybe a taint in the integrity of the case, so reasonable doubt, but at the same time, it's kind of a jury nullification thing. I think having this on in your arsenal, that this whole team over there, everyone on that side of the aisle, they're messed up. They'll do anything to win. You heard them do this. I think it could be very helpful for Clenny to stay in Miami-Dade. Just saying, personally. But still, call it out. Call it out. Because it puts the record, it preserves this issue for the record if that's necessary. Despite the privileged nature of the material he accessed, ASA Quinan did not acknowledge the privilege. Instead, the prosecutors continued to argue. Prosecutors, again, because we're arguing here that Hogue and Abuhoff are now participating and adopting the position of Quinan. Instead, the prosecutors continued to argue that the communications were not privileged, even after reviewing materials that plainly laid out defense trial strategy. Although the state did raise a waiver argument, it was not based on case law governing opinion work product. The privileged document, how many times are they going to say the name of the document? They're being funny. Entitled Courtney Checklist of Things to Do - Privilege DocX, plainly contained detailed trial strategy, defense witness plans, and mental impressions of counsel. It is hard to imagine that any experienced attorney, upon reviewing such a document, could believe it was not protected opinion work product. Florida law is clear that waiver of privilege only occurs only where the disclosing party should have reasonably foreseen that the materials would fall into the hands of opposing counsel. The state did not and could not argue that an email communication from defense counsel to Clenny's parents discussing trial strategy met this standard. Yeah, does anyone in the chat have the expectation that prosecutors should have been able to see this email? Versus it, you know, being the expectation of the attorneys and the family that this email was meant for their own, you know, in a vacuum communications. Crazy. Okay, wait, let me go back and catch this up. Idiot wind. Okay, what case? What case is this? Is this the Juca case? Okay, Chloe says advertising something. Sorry, I want to go back and see TV show. Okay, Anna Siga Nicolazzi, right? Is this it? Okay, I think that's what you're talking about. So great, I gotta learn how to say these things. But a lot of TV shows about this, a lot of coverage. And to read more on it, Idiot Win says there's a podcast called Crawl Space that did 8 episodes on it, scattered over time and with new developments. It's excellent. Also, of course, the court documents. Bettero's on the appeal. So this is why I was going backwards. I saw Attorney Betterow was mentioned. Shout out to him. If you're following the Karen Reed case at all, Betterow filed for admission, wanted to join Karen Reed's defense team, right? That was denied by the judge, but he's still pretty involved in the hot mess going up there in Canton, Massachusetts. So to hear that in a different matter, he's on the appeal. I guess one of the easier things here would be, let me pull up his channel. Does he have his own channel? Or does he just guest on other channels? All right, we might have to do an X, a Twitter for Mark Betterow. Because actually, now that I'm thinking about it, I do remember him tweeting, you know, that he was changing his criteria for where he was guesting on YouTube. So maybe he doesn't have a channel. So we'll do a Twitter link. So this is Mark Betterow. Link is in the chat there. But that's super cool. And let's see. And Chloe's going to try to look at some court documents. So shout out to Chloe Albert's Revenge. And Chloe, I'm still waiting to hear more about you in round 2 of this Karen Reed trial. Like, you haven't made that much of an appearance yet. But shout out to that. Really cool to hear. I mean, it seems like an old case, and then we have this overlap here with a familiar face from the Karen Reed trial. Small world, small world. So yeah. We've got all of this privilege stuff. It's hard to imagine that any experienced attorney, upon reviewing such a document, could believe it was not protected opinion work product. Florida law is clear that the waiver of privilege only occurs where the disclosing party should have reasonably foreseen that the materials would fall into the hands of opposing counsel. The state did not and could not argue that an email communication from defense counsel to Clenny's parents discussing trial strategy met the standard. As this court found, there was no reason why defense counsel should have reasonably anticipated that such a privileged communication would be accessed by the prosecution. And they're referencing the order granting, in part, the motion to compel the deposition testimony. Subpoenas for depositions had already been issued. And let me stop here. So I tried to request this, and I'm annoyed about this. I tried to request this order, and the state attorney's office, who shout out to the state attorney's office, like, their document people, they're so responsive to me when it comes to whatever I email them. And they said they didn't have a copy of the order, but referred me to the county clerk. And I wrote to them. Like 2 weeks later, I got an email like, we've received your request. And then I forgot about it until now. They never sent anything. So just a little mention there. You've heard me praise a lot about the quick response time when I do request documents in the Courtney Clenny case. But when they weren't able to handle this particular request and I had to go elsewhere, slow, non-responsive. Subpoenas for depositions had already been issued, and the depositions of Arthur Cupp. This is the neighbor. I didn't know about Bobby Branton, so that might be a new one. That might be the guy that lived. So let me pause. Arthur Cupp is a neighbor. So when in Miami, when Courtney Clenny and Christian Obumseli were living in this Miami penthouse at One Paraiso, their neighbor lived in a nearby building. It was like across the way. They could see each other's windows. Arthur Cupp came and spoke to employees and police the day of the incident. He came in and he's like, hey, I thought I should come over. My girlfriend told me I should come over and say something. You know, it looked like they were fighting a bit this weekend, blah, 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 blah. So the defense has hooked on to this witness because it's an eyewitness to a possible altercation where, according to Cupp, it seems like Christian was the one using his arms in some manner towards Courtney Clenny. He says he saw the man and then the girl across the way a few days before this April stabbing or knife throwing. So obviously an important witness for the defense, but at the same time, there's huge reliability issues there, right? You saw this from across the way. You only saw a clip of it. You couldn't see the whole thing. You saw arms moving, but you don't know if it was in restraint or trying to hit. Like, there's a lot of holes that the state could poke to not try to call this witness a liar, but just say he's unreliable. What he believes he saw was unreliable for one reason or another. So really important that the state isn't on advance notice of exactly the way the defense has strategized around presenting this witness to the jury. Same thing, Bobby Branton, I'm not exactly sure, but this could be there was a neighbor that lived on the floor below Courtney and Christian when they lived in an apartment in Austin, Texas. If this is the same guy, he said that one day there was arguing upstairs, like audible, it was loud, and a painting of like a tiger fell over the balcony and landed in his balcony. So if that's Bobby, that's another a witness where maybe you'll have someone saying that the fight was mutual, or it seemed like it was more him than her. So important witnesses that the state, they could go and interview and sit with these witnesses if they agree to an interview. But if they don't, the prosecutor shouldn't just be able to go and read everything the defense has used and communicated about these two people just so they can get their own ducks in a row. It doesn't work like that. So yeah, so the subpoenas for the depositions had already been issued, and the depositions of Cupp and Branton had already occurred before the defense became aware of the extent of the breach. Therefore, prosecutors who had been exposed to privileged defense trial strategy participated in critical witness questioning while tainted by improperly obtained information. This is a huge problem because the way somebody asks a question, especially this is going on, I don't know when I know they witnessed Arthur Cupp at some point pretty early on. I believe he was mentioned at like 2022 already. So you have a prosecutor that goes in and asks certain questions. Human memory is weird. If you're asked a certain question and then 2 years and something's inserted in that question and you're thinking about the question as you try to answer at that point in time, 2 years from now, when you're recalling something, your memory may have adapted to the way that question was asked. And you might misremember or remember more or remember less or remember something entirely new because your memory is recalling something that was said during an interview rather than something you actually remember as a percipient witness in that moment, space, and time. So I don't think this is insignificant. Because they could already be getting into things that would go to poking holes at trial. They could be asking this witness something 2 years now, and for the next 2 years, he's sitting there going, maybe I didn't see what I thought I saw. And his whole opinion could change before he's a witness taking the stand at trial because of the way the prosecutor approached them. So a bit of issues here. Let's see. Although ASA Khalil Quinan appears to have been the principal violator of privilege, as he admitted to searching the iCloud data without implementing any filter protocols, but for his actions, the privileged information would not have been accessed. Responsibility does not end with him. All three prosecutors, Quinan, Abuhoff, and Hogue, discussed the team Courtney chat. While ASA's Abuhoff and Hogue have now stated under oath that they did not personally review any privileged communications, this alone does not insulate them from disqualification. Although it appears that ASA Quinan continued to search the iCloud returns, located the Courtney checklist of things to do, privilege docx trial strategy document, and did not inform his supervisor, counsel, or any other attorney about the privileged nature of the document, it is difficult to accept that ASA's Abuhoff and Hogue argued in court that the checklist was not work product privileged without having seen it or discussed it with Quinan. Right. How can you argue to a court? How can you make a representation to the court? It's fine, there was nothing privileged in that thing. While also trying to maintain that you don't have knowledge of the contents of that thing. Seems like saving face. Their continued participation in this matter and formal endorsement of legal positions derived from privileged material presents an appearance of impropriety that cannot be overlooked. Florida law does not require actual misconduct by each individual prosecutor to warrant disqualification. The failure to intervene, supervise, or filter, and the ratification of tainted conduct are sufficient to create an intolerable risk of prejudice and erode public confidence in the fairness of the proceeding. Even with no knowledge of the second breach, their endorsement of that legal position raises even greater concerns. What is of paramount importance is that Courtney Clenny receives a fair and impartial trial. See State v. Fitzpatrick at 762. And again, I'm really thinking the fair trial might be in another jurisdiction, and in a way that this hot mess that the Miami-Dade State Attorney's Office has caused won't get in the way of a conviction. Right? So a fair and impartial trial is Courtney Clenny's right, but in her case, I really think it would remove some of the avenues that might make a juror sympathetic to Courtney Clenny outside of the facts of the case, if she's tried somewhere where she can't bring up the games the prosecutors have played. So, fair and impartial. You're wishing for it, and I believe you should get it. But I don't know if it would be better for you if you're looking for an acquittal. The second argument is actual prejudice and the necessity of disqualification. Florida law holds that disqualification of a prosecutor requires a showing of substantial misconduct or actual prejudice. Downs v. Moore and Farina v. State. Actual prejudice requires something more than the mere appearance of impropriety. That's McWatters v. State and Meggs v. McClure. However, on a case-by-case basis, specific or actual prejudice will not be required where the appearance of impropriety is strong. That's Huggins v. State. Disqualification is therefore a prophylactic remedy for likely future prejudice, not a punishment for past wrongdoing. So it would be in the means, in the effort of maintaining a fair trial. Not to punish, but to make sure someone's rights to a fair trial were preserved. Although trial has not yet occurred, the irreparable taint created by the prosecution's exposure to detailed defense trial strategy and mental impressions establish actual prejudice now. Prosecutors who accessed privileged materials participated in the depositions of defense witnesses, including Arthur Cupp and Bobby Branton, before the full extent of the breach was revealed. The risk that privileged information will consciously or unconsciously influence trial prep, strategy decisions, or witness examinations is not speculative, it is inherent. And I agree with that. I don't know if it'll be enough for a court to agree that this prejudice can't be ignored, and thus the whole state attorney's office has to be disqualified. But I don't think this is just an argument for the sake of argument. I think they have a basis to argue this. Idiot Win says they'd probably get a special prosecutor. This whole special prosecutor thing, I don't know if this is a new phenomenon or not, but this special prosecutor thing does not seem to be going well for different cases, high-profile cases across the country lately, in my opinion. Well, I guess not really my opinion when it comes to the Russ case, because we have a disposition there where not only case, mistrial with prejudice, but Carrie Morrissey fought to get that reversed, to be able to retry Alec Baldwin again. And it was like, no. Like, volunteering to take extra L's, right? So that's not an opinion. Like, Morrissey got the L as a fact on that one. But Hank Brennan, that's an interesting one. Obviously, Nathan Wade comes to mind. It seems like maybe we should just, pay attention to cases with special prosecutors, because they've been going in interesting directions lately. Yeah, please let it be Carrie Morrissey. Chloe says bring Carrie Morrissey in here. Oh, boy. Let's see. Yep, Florida law does not require the defense to show that the privileged information will be used at trial, only that the exposure itself creates a real risk of unfairness that the defendant otherwise would not bear. The core purpose of disqualification is prophylactic, to protect the adversarial system from contamination before irreversible damage occurs. And this is kind of like a hint, do it so it doesn't become an appeal issue. Maybe that's compelling to Judge Laura Sheeran Cruz. Moreover, the prosecutor, and if I didn't say it, if you guys haven't been following this, it's the same judge. So this is the same judge hearing this motion for the sake of this murder trial that also presided over the laptop case. She was presiding over both. So the same person who already ruled that Quinan did too much gets to hear this. Moreover, the prosecutors involved have misled court and counsel about the extent of their review of privileged materials and have failed to acknowledge their misconduct, continuing to assert that no privilege attached to plainly privileged materials. This misinformation and refusal to recognize wrongdoing amplifies the risk of continued prejudice and undermines confidence in the fairness of these proceedings. They continued to do it when they pretended they stopped and weren't doing it anymore. They continued to do it. You ordered that they were doing it, and then they continued to still argue that it wasn't privileged. So what's going to make them actually stop? The voluntary withdrawal of ASA Quinan does not cure the prejudice. His misconduct has already tainted key proceedings, including the questioning of witnesses, and the remaining prosecutors either ratified or failed to intervene in his actions. Yeah, because what happened when he went to his supervisor? It's like, because again, we have these two different circumstances where he volunteers with the laptop communications. I only looked at a few before and a few after, and I went and consulted with people, including my supervisor. So that's this office. That's this same state attorney's office. And then I stopped, but then I didn't really stop. And then the next time I didn't go to them at all. So what was your supervisor doing the first time? And for the remaining actions, were you being supervised at all? They just let you do all willy-nilly? So, and again, that's from Quinnen himself in his deposition, that he says he went to his supervisor on this. It's not just like they're guessing. So in conclusion, despite the prosecution's claims that they did not read any substantive material, the appearance of impropriety within the state attorney's office is profound in this matter. Without a filter protocol in place, which is just crazy. I don't think I've reacted strongly to this because it's an issue that has already been addressed last year, that they didn't have this filter protocol. So I think it's like, it's not the new information for me in this document, but let me underscore that this is astonishing in and of itself, that they simply don't have a filter protocol to go through a bunch of documents where in the affidavits, they're clearly naming the names of attorneys. They don't think to have a filter team just in case for their own sake. It seems more like you didn't want to filter the communications. Intentionally, you chose not to filter the communications. And it looks like the judge agreed. But the court cannot guarantee who else within the state attorney's office had access to the privileged communications, necessitating the disqualification of the entire office. As previously stated, disqualification is a prophylactic, they're going to keep saying this word and beat me up, for likely future prejudice. The actions of the state attorney's office have cast doubt on the integrity of the entire case. A criminal defendant is entitled to at least a basic level of confidence that the prosecution will proceed fairly and honestly. That confidence has been eroded here. The prosecution's misconduct in this case has been validated by this court's rulings, raising the question of whether further misconduct exists. Consequently, Courtney is now burdened with the need to scrutinize every action of the prosecution. Good point. Fearing continued improper conduct. This is precisely the type of prejudice that disqualification is intended to prevent. So she's selling her house. She's selling her house. Now, in a perfect world, every defendant would have the resources to comb over every inch of every little thing. Right? Just in a perfect world. But that's not the case. Public defenders are going to be strapped for time and resources. They've got to ask for the court to grant them money every time they need experts or whatever. And then for someone who has retained counsel privately, if you want them to do more scrutiny because the prosecution needs the extra magnifying glass on them, that's more billable hours. So in a very succinct one sentence here, I think this is just a great point. You've got a defendant who now has to pay their attorneys until they can't to make sure at every corner the state hasn't continued to do what they've shown that they will continue to do. So, just crazy. Okay. So I might be missing context, but that guy Nick says, in reply to Fun Size, oh wow, yeah, that makes her a bit sus. Is she saying he was abusive? So, a few months ago, maybe at the end of last year, she filed a notice of intent to rely on battered spouse syndrome defense. I'm not sure how that's gonna fly, because she's got these notes where she's saying that, early on in their relationship already. She was writing notes to herself, you know, you hit him to relieve tension, to relieve stress. She didn't write, we were hitting each other and we do this to relieve tension with each other and we should figure it out. She was writing a note to her to tell herself to stop hitting him just because she's upset and needs to release the tension. So, I think that's where it's going to get interesting, and that's why I said earlier in this video, I'm not sure that she's going to rise and climb this burden. You know, if you're asserting a justification, and battered spouse syndrome, if you're going to rely on that defense, that's a justification. You have the burden of presenting enough to make the case for that justification. Right? So the state still needs to do their job and prove the elements against you beyond a reasonable doubt. But when you're putting forth an affirmative defense, relying on a justification, you as a defendant now bear the burden to make your case for this to the jury. And I'm not sure if we're going to get there. I'm not sure if we're going to get there. But again, I don't know what's going to be admissible versus what's not going to be admissible. So, yeah, so I don't know. This is precisely the type of prejudice that disqualification is intended to prevent. The voluntary withdrawal of ASA Khalil Quinan does not and cannot remedy the prejudice already caused. The remaining prosecutors, having ratified and defended the privilege breaches, cannot be permitted to continue. Given the pervasive taint caused by both the direct misconduct and the supervisory failures, disqualification of the state attorney's office as a whole, or at a minimum, the disqualification of the remaining prosecutors assigned to this case, is necessary to preserve Courtney Clenny's right to a fair trial and impartial trial and maintain the integrity of the judicial process. So we've got Sabrina Puglisi, Diana Karamis, and Frank Pareto here, all signing off. And if you guys, I think we had that one exhibit I skipped that was a list of the 60 names. So that's here. It's a lot of names. I mean, I don't really know what to make of it, but I do agree. If we're at a point where we can't just trust the the state attorney's office at face value, if they were to say, well, there was an issue that made it look like all 60 of them access this thing, but it was just a glitch. Can we believe that? Do we need to interview 60 people? And does it make sense to interview all 60 people, or should we just give a different remedy? So there's that. And yeah, that guy Nick, that's where I am. I generally distrust prosecutors as well, but that's a lot of evidence against her. And it's really why when this all first happened, I was like, I'm not really interested in covering the Courtney Clenny case. I kind of like cases where there's a bit more nuance in how I look at the facts, right? I like it to look like Travis Rudolph. I was like, what happened with the Travis Rudolph case? If you're not familiar, Travis Rudolph, former football player, it was a girlfriend, but they both had other relationships, but it was like a somewhat serious ongoing relationship with this girl, Dominique. Dominique finds out he's messaging this other woman. She's also married. She goes and tells her family members, her male family members, that Travis Rudolph was beating on her, hitting her. So her family member and 3 other guys, this group of 4 guys, pull up to Travis Rudolph's house where his brother and his mother live, and they want to press on Travis Rudolph because we're under the impression that you were putting hands on our female relative. Well, it gets kind of crazy. People think that guns are coming into play. The 4 guys start to get in a car and drive away. Rudolph's brother starts pursuing them. Travis Rudolph's freaking out, pursues behind them. And then the story ends up being that as the car is reversing, so the front window is facing where Travis Rudolph and his brother are coming up, that the passenger in the window pulls a gun and has it pointing through the front window. So Travis Rudolph takes his gun, fires, and kills the guy in the passenger seat. Well, I thought that was a really interesting case because there's a pursuit there, right? So if you don't think about it, the pursuit makes it seem like, well, how does that become justified use of force? Well, what makes it justified is after that pursuit, in a split instance, if the jury establishes that, yes, we believe that it's a fact based on testimony that the passenger created this deadly threat by raising his gun and pointing it through the front windshield, now in a split instant, even though the brother pursued and Travis Rudolph was following behind his brother, in that instant, now there's a new threat that justifies the use of force. And he was acquitted. I thought it was the right decision, but there's a lot of gray area there. And at the end of the day, it all started because somebody made a fake claim to their family members that they were getting beat on because they were upset that he was talking to another woman. And all of that, extremely tragic because the guy in the passenger side, he's dead. Like, that's why it all went to trial. It was a murder trial. But just the whole mess that we had this all happen just because somebody was upset about infidelity. And then ring camera footage comes out where Dominique is actually hitting Travis Rudolph. He's like walking into the house and she's behind him going like this. And it's just one of those things that when stuff like that comes out, I get very interested in a case. And I do love self-defense. Because again, it can change in an instance and juries can be finicky as is, but a self-defense case can come down to the jury understanding that we're asking you maybe about a split second in time. And at that split second in time, was this use of force justified? And it might not have been justified a second ago, and it might not be justified the second after, but was it justified in that instance? So, just crazy. Okay, an Idiot Win says, shifts it to make it the state's burden to prove that it was not self-defense, not just prove the elements. And yeah, Travis Rudolph was interesting, and Mary says, I thought it was the right decision too. Yeah, I was happy to see his acquittal. I was definitely happy. And again, interesting, right? Because that was a Florida case, and maybe a Florida jury is more... in the jury's mind, even though they're supposed to be deciding on that split second instance, right? Who knows? The jury could have decided, we don't want people to think that they can just show up to our house. We don't care that they were trying to drive away. They were still willing to be, to come up to my house and fight me and confront me and fight my family. Fight my family while my mom was inside. And I think the mom came outside. So for all we know, the jury in their minds, their decision could have been anchored in the principle that we don't want people to think that they can just do this type of thing. So we're going to back Travis Rudolph regardless of what happened in that split second, right? I don't really know what was in the jury's head. But maybe being in Florida, maybe that's how we got this acquittal. So Peter Ortiz says Reed's is a case of jealousy. And I can't shake that either. That's kind of where I am. I don't really know... I don't know if I think Brian Higgins was jealous that he didn't have a shot with Karen Reed that he thought he may have had. I don't know if I think the jealousy comes into play after some accident happens with John O'Keefe as he's walking up to the property or entering the property, and an accident happens, and because they don't like Karen anyway, they said, we're just going to pin it on her, pin it on the girl. Like, I don't know where I believe jealousy comes into play most significantly, but I think it's there. I definitely think it's there. Let's see. Oh, so Nem, are you thinking the Courtney Clenny case here? Not sure about self-defense, but we'll be interested to see if it's manslaughter or second degree. I've got to review it. A while ago, I did the stream going through the Florida, the way it's codified and some case law about how she's being charged. Because remember, we have that enhancement because of the knife, right? So if she's convicted, and Florida is honestly, I know there's all these Florida man jokes. It seems like you can do anything in Florida, but Florida really doesn't play with their enhancements and their minimum sentencing. That's the reason she could be looking at life, is because of that knife. And I don't know if I think the prosecution will ask for a life sentence if she's convicted and, we get to the sentencing phase. but it's on the table because that knife is in play. So, but, yeah, so Angie Lee, no, this is okay. So Angie Lee says, the Reed case I didn't watch the first time. As of now, I think she hit him by accident. Don't attack me. And that's okay, because I think this is important for everybody to consider, you know? You hear that somebody is dead on the lawn and people were driving and people were drinking. I think everybody should understand that the most reasonable explanation with that context, until it's challenged, right? And then you can reevaluate as you hear new information if you still think or not. But it just seems like, well, how else did he get there? How else did he get there? It's possible she hit him on accident, and that's why she had no idea next morning why he didn't come home. That checks the boxes. For me, it's just that there's just too much to explain about Jen McCabe and everything else that was going on. And at the end of the day, I really think factual innocence or factual guilt for Karen Reed, the state and the police all together, you know, they're part of the same machine. What a crappy investigation through and through. An entirely crappy investigation with Trooper Proctor. Just crazy. Oh, okay, so Idiot Win says you can face life with murder too, even without the weapon enhancement. Sarah Boone, for example. Sarah Boone. I saw, if you guys were interested in the, I almost said Karen Boone. The Sarah Boone. And it might be today. I don't know if you guys know Corgi-san. She might be somebody you remember from Depp v. Heard. I think she got a ton of following during Depp v. Heard, but she still covers a lot of trials. And I hadn't watched her in a little bit, but I saw she was doing Sarah Boone sidebars. So the transcripts are now out for Sarah Boone, and she's been covering them. So she's really easy to listen to. Her chat's really nice. I've never talked about her before because, like, honestly, I don't really think it's been so long since the Depp v. Heard trial that she fell off my radar, but she was someone I watched a lot back then. But there's her link in the chat. I love a good transcript reading, and she's doing Sarah Boone sidebars, so what could be better than that combination? So go and check that out. Sarah Boone was another wild ride of a Florida case. And again, it was announced that, not announced, but Clenny filed the notice of intent to rely on battered spouse defense right when Sarah Boone was happening. So, you know, it kind of just seemed like one of those things that was coincidental. Let's see. Yeah, and Trikisha says, yeah, he made it in the house because his watch indicated movement. So I have questions in the Karen Reed trial where the prosecutor, Hank Brennan, wants to introduce and get the jury to hear about Jen McCabe's, like, heart rate while they first pulled up to the curb at 34 Fairview, find him, and she has to call 911. She goes to speak to police officers, and she also says she was doing CPR. And Brennan wants to introduce her heart rate monitor to suggest that because her heart rate was completely normal, that she didn't kill anybody. But it's weird to me that her heart rate would also be normal when she's calling 911, speaking to prosecutors, saying she was in shock. She was, like, freaking out because this guy's dying on the lawn. And she's also doing chest compressions. And she's claiming she did chest compressions. And then her heart rate doesn't move at all. And that might be something where maybe it shouldn't be that significant, but it's just a prosecutor's strategy. I was like, why would he want to introduce that? Because it doesn't really help his case either. So just a whole mess, a whole mess. And if you guys are looking, if anyone in the chat, and I'm not saying, like, Angie, go watch trial 1, because I think it's interesting. If you have not watched trial 1, I think it could be very interesting just to watch trial 2 and be our role play juror, right? I don't know where you're watching it. I'm typically watching with Millionaire Mel or Andrea Burkhart during the day, and then potentially Criminal at night. But, and a few other places, but it's just too much to try everywhere. But if you do want to rewatch trial 1, Millionaire Mel just did a replay all the way through trial 1, like starting about 2.5, 3 weeks ago. And, you know, she cut out all the breaks. So I think it took her like 5 days a week for about 2 weeks she was doing it. So if anyone wants to go watch trial 1, that's a recent way to go do it, where it's succinct from like gavel to gavel. So without any extra coverage of motions and pretrial hearings and all the stuff that's outside the presence of the jury. So Peter's argument is Karen is a Karen, so she did it. Dang. Dang. Just guilty by name. Guilty by name. Yeah, and for Always Forever for Life says he died from head injury and now they're covering it up because everyone are cops. And that's the thing, like, it could have been an accident. He falls back, hits his head on something, and then they just don't know what to do with the guy, but they don't want to get in trouble at all. So they rather come up with a story. Like, I don't know. Justin TV says he's trying to prove Jen's innocence. That's why. Yeah. Okay, so Angie's watching Over with Corgi-san. So there we go. Maybe I'll see you over there. I've got to go catch up on her stuff because I didn't even know she was covering Karen Reed. Oh, there you go. There she is. So I'll pop in. I haven't hung out there in a live in a while. I've been catching her replays, not on Karen. But she does a lot. I didn't watch her Lori stuff either. But Corgi is very, very good for transcripts, motions, documents. Like, she's big into covering all those in-between details. So I do love it over there. I just haven't been there in a while. So I'm going to come visit you over there, Angie, this week. I'm going to come watch one of the Karen Reed days over there. Not Monday, though. We're going to do a little Cinco de Mayo here, and I'll probably have to work, so I'll be watching at night on Monday for Karen Reed. Maybe Tuesday. Maybe Tuesday. Let's see. Yeah, and Trikeisha, this is not logic brain for me, but I have a hard time imagining just rehoming a dog without immediate reason. If I didn't rehome the dog when the dog was aggressive with another dog, if I kept the dog, why would I randomly later on down the line for no reason at all decide to rehome the dog? And like, I'm not trying to downplay the other evidence in the case. That's a pretty emotional interpretation of a situation, right? But at the same time, I guess if I was a juror, I'm not going to lie to you, I'd be thinking about that in the juror box. I'd be like, who would rehome their dog then, now, but not back then? So, crazy. Interesting. Daffy Daff says Lawyer You Know does nightly recaps. That's crazy because I've actually been catching his coverage more in the mornings. Like when I wake up, and maybe it's different. The stuff I see is usually with Big George in them. And it's like he uploads them at 8 in the morning or early in the morning, or it comes up on my YouTube feed before anyone's gone live for the day. So I'll like put it on 2 times with Peter from Lawyer You Know. So I didn't know he was actually doing those at night. They're probably just coming up on my feed in the morning. But I do love it over there, Lawyer You Know, as well. Let's see. And Raynette says everyone rehomed. Yeah, like they sold the whole house and moved. Now, I don't subscribe to the idea that because they took a lower than asking price on the home that they were desperate to move, because their house was listed for, I forget the days on market, but it was a long time. And it was probably just overpriced. Their home was probably just overpriced, but they sure did all move. Who's live right now? What are you guys gonna go do after this? Let's see. Who is live? Okay. Everyone just says upcoming, and YouTube doesn't give me timestamps to reschedule. I think, okay, I see something upcoming with Survivor Speaks and Happily Angry Lawyer. Let me check the time. Let me see if that's coming up. Because that's going to be Moontunk updates, you guys. And they're still, I don't know how much they're going to have ready to go, but I know that Judge Whitaker's recent resentencing is not the end of the fight. Okay, that's going to be at 4 p.m., so that's 3 hours away, but it looks like it's today. So in 3 hours, 4 p.m. Eastern, survivor speaks and happily angry lawyer. Brooklyn says brother counsel is very good. Tomorrow at 10 a.m. they have a new recap. I think, did Andrea guest on brother counsel? I think I have that in my watch later. I have like a graveyard of watch later content that I haven't gotten to, but I believe I know what you're talking about, and I believe Andrea Burkhart did a panel or like co-hosted right before trial started. I think I'm so far behind with Brother Counsel. So Brother Counsel's doing tomorrow at 10 a.m. a recap. So that's one. And Trey Keisha's over in Lawyer You Know's recap right now. Is he live right now, or you just... Okay, I see stream 19 hours ago. Let's see. Mary W says Cinco de Mayo at the courthouse square in my town is packed. Taco stands everywhere. And I want to be in the middle of all those tacos. Hold on, that sounds a little sus. Just kidding. I love tacos, the food tacos. That's really fun that the town does the whole town square thing for it. Oh my god, Runkle of the Bailey. Runkle of the Bailey's also good at night. I catch some of his recaps at night. When I'm able to watch during the day, I like going over to Runkle at night because it's a lot more commentary with Runkle. He's hilarious. Let's see. Is he someone that's gotten an email about... Someone's been emailing, like Andrea Burkhart, all these like long-winded emails about how they're horrible legal streamers. Has Ian gotten one of those? Yeah, I don't see Ian live. It's only me. Alright. Do you guys want to go to... Wait, Full Drinking and Half Thinking's doing the gorilla thing right now. The gorilla discourse. So there's that. Aw, Kim R. I love this. Kim says normally sighs are annoying. Judge Canoni, but you have the best sigh, always makes me smile. I love that. I love that. I think it's a whole family thing, because I hear my brother sigh, and I didn't ever think about it until you guys pointed out my sigh. But now I realize we both sigh the same way. So I don't know if it's like a family thing. Oh! Guys, Potentially Criminal is covering Martin v. United States. This is in Georgia, you guys. So the FBI raided the wrong house, and because of like qualified immunity issues, the family can't get any compensation for what happened to them. It's gone all the way up to SCOTUS. So there were oral arguments, I think, on Tuesday. Really, really, really good arguments from the attorneys representing the Martin family. Because there needs to be some type of remedy when a family has their house raided by the FBI and it's the wrong house. There has to be some type of remedy. So this is Martin v. U.S., and that's Potentially Criminal, Sean Martin. Great oral arguments. We might redirect there because it starts in a few minutes. Potentially Criminal is a defense attorney, but used to be a prosecutor, and, you know, balls and strikes over at his channel. He does not take it lightly. Like, his perspective on Fulton County, YSL, is bulldoze the whole courthouse, bulldoze the whole building. So that's what you're in for over there. I think that's the next thing coming up that's like legal related. Everyone else is starting later. So with that being said, you guys, whose birthday is it? Is this for Peter? Yeah, guys, as we're exiting here, make sure you say happy birthday to Peter. We will be live for a little bit we're going to cover like a hodgepodge of things on Monday. We'll just get live and hang out for Cinco de Mayo. But it's also Peter's birthday. But if you can't join us on Monday, if you will be watching Karen Reed, because it's going to be live at the same time, I'll go live for like 2 hours and then get you guys back to your Karen Reed stuff, promise. But if you're not going to hang out with us Monday, say happy birthday to Peter. Raynette, didn't you have a birthday recently? I think at the end of April, not a May birthday. I know someone else had a recent birthday as well, so happy birthday if that was you, Raynette. And hey, Amy E, good to see you. I'm seeing Amy E say hi. I always hijack someone's hi to somebody else. But good to see the beautiful Amy E. Amy E, you just did... I mean, I think you've done a lot more than what I'm about to say. Because you've got content like daily. Let me get her link, but make sure you guys follow Amy E as well. Oh my gosh, you guys. So Amy E, and this is 13 minutes ago, so go check this out. This was a little wild. The McAlberts confronting Julie McAlbert confronting Aiden Kearney, Turtle Boy, Karen Reed stuff. Tons of content. Yeah, you've got tons of stuff here to keep you guys busy. So make sure you just subscribe to Amy E and hit the notification bell. Because whatever it was that I saw that I thought was crazy. And you came up on my other channel. So I have a channel where I typically watch like video gaming stuff and I try to keep the algorithm separate. But it was you and it was an upload. I don't know, the thumbnails look different. It was a police body cam video though, but you've got a ton of that footage there. And it was cool to see you come up in a different algorithm. Because I don't think that account like searches for this type of thing. My birthday was back in March. My birthday was in March. Okay, yeah, so Raynette and Here Comes Drama. There we go. So, Here Comes Drama, if you're on replay, happy belated birthday to you. And again, happy belated birthday to Raynette. Yes, FFS. I'll post it again. Go follow Amy. So there you guys. We'll do a redirect over... potentially criminal starting in 2 minutes on Martin v. United States. And I don't know if he's going to do a transcript reading or replay the oral arguments or what. I read the oral argument transcript of the attorneys for where was it? If I can find it, the attorney that made the oral arguments, great content over on X. But like an idiot right now, I don't remember his name. Okay, so Patrick J. Como. Hope I'm saying that right. So I'm going to link over to his X if you're on X. Great attorney to follow. Does a lot more cases than just this one, but this is an incredibly interesting argument that you're going to hear if you come over to Potentially Criminal. Patrick J. Como. So there you go, you guys. Oh, did I miss? Oh God, I'm sorry. Thanks, Peter. I'm sorry. Peter said super chats with the boom. Sorry. Don't F with justice. Good to see you. FFS said, thanks so much, FFS. Says, Kat, the legal system is why I have trust issues. I mean, I have other reasons for having trust issues. Remember, it's regular people that get into play in the justice system, right? So people are people. And just because they hold a title doesn't mean that they do nothing wrong. So yeah, but the legal system in a lot of these cases definitely gives me bigger trust issues. Thank you, FFS. Peter Ortiz says, Kat, I looked for you on Classy last night and got to pick the winner. Oh my gosh, you got to be the judge? Oh my gosh, I have to replay. Guys, I was doing web dev late last night. It was not a good time. So I went from Nick Sorrow's birthday stream and had to leave in the middle of it to connect with a web developer because we're in like a 15-hour time difference. So Friday nights typically coordinate something when he has free time on his Saturdays. So I did not get to make it to Club Classy. Sorry I missed the Club Classy for your birthday. Very excited to see who you picked, though. Very excited to see who you picked. Peter Ortiz also says, I'm leaving Fort Lauderdale after my birthday on the 5th. So you're going back to somewhere colder. It's been beautiful in Florida, you guys. This is the time of year to come visit Florida. July is too hot. Peter, hope you've been having a great time in Fort Lauderdale. That's a great birthday treat. And I'm glad you're staying in Fort Lauderdale for the 5th. I think that's the place to be. Thank you so much for the support and for hanging out with us today. The he cooking emojis. I always forget that we have, the he cooking emoji can last a long time. But I always forget we have these YSL emojis, and every once in a while they become relevant again. Thank you so much for your support, Idiot Wind. Again, earlier you gifted like 1 million memberships, so super appreciative. Also appreciate all the insight and the corrections you offer in the chat, so I get it right up here. Thanks for educating us and for supporting this channel. And you guys, we're going to go over and see what Patrick J. Como argued in Martin v. U.S. Again, Supreme Court arguments, very big deal. Hope to see you over there. Survivor Speaks about 3 hours from now with Happily Angry Lawyer talking about the Moontoon case. And then tomorrow, Brother Counsel's doing a Karen Reed thing. We've got a lot of stuff, so I'll see you guys somewhere. And if not before Monday, see you Monday. Bye, everybody.